You are now listening to the Fighting Back Podcast, and here's your host, Jessica Travis.
Welcome to the Fighting Back Podcast. I'm Jessica Travis, and I am here with the amazing and brilliant Mary Walter. Hi. Mary Walters is board certified in appellate work.
Appellate practice.
Appellate practice.
By the Florida Bar, correct.
And that is different from the criminal appellate world that I'm used to.
Correct.
Because you handle mostly civil appellate cases.
Correct, yes. Interestingly enough, for the board certification that the Florida Bar has, it does have two. I think that stems from how it was created. On our general appellate test, they do test us on some criminal aspects, so we all are able to do both. But criminal appellate practice just being as important and significant as it is, our practitioners can be certified specially.
So with appellate practice, that means that you, unlike me, are not in the courtroom.
Correct.
You are not going in front of the jury. You're not doing the jury trials and things like that we kind of see on TV.
Correct.
You really do the behind the scenes after the jury trial is over kind of thing, right?
Yes, absolutely. So one of the key aspects of appellate practice is what we call trial support. And that actually is kind of a behind the scenes from a trial scenario. Whereas you're going out there, you're presenting your case, you're talking to the jury, I'm maybe making some notes. I'm thinking of some arguments that you might want to think about. I'm looking at maybe we need to say something to the judge to set some things up in case the case goes our way or doesn't. And that's a very key aspect of what we do as appellate practitioners. And then the second aspect of that is the actual appellate process, which involves talking to a higher court about the trial court and what they did.
Okay, so I want to really kind of dig into a real life example with you so we can figure out exactly how trial courts work and how the appellate court works and really like how it all fits in.
Yes.
So let's take this case that you might have heard of. P-Diddy, Sean
Correct.
Puff Daddy Combs.
Yes.
He had this little thing in court a while ago, right?
Yes.
Familiar with that?
I am.
So he was acquitted on some of the more serious charges.
Yes.
And he was found guilty on some of the less serious but still felony charges.
Yes.
And he's currently sitting in custody.
Correct.
So tell me, after the jury trial ends, so the jury comes back with their verdict, they have acquitted him of the charges, found him guilty, what happens next in the appellate world?
So after the jury comes back, they're going to find their judgment. They decide who was telling the truth, who wasn't telling the truth, what was going on, and they make that ultimate call as to guilt or innocence. The trial judge then gets it from there, and after some maybe minor post-judgment motions, things like that, will ultimately enter a judgment, which is just sort of a kind of a final paper on what the jury did.
And that was done.
That was done here. So after that happens, then the parties that are unhappy with it, they can take it further. So in the criminal world, it's a little specific. It's different from what I normally do. The state can't appeal the acquittal. We have protections, constitutional protections.
So I want to stop and make sure we dig into that.
Yes.
So
that's very important.
Yes. So if somebody is acquitted of some charges, like in this case, he was acquitted of the more serious charges.
Yes.
The state is not allowed to appeal that acquittal. The jury's ruling is final.
Correct. So there is a little bit of a caveat to that, but for the most part, the state cannot appeal that acquittal. They can't charge again. There's a double jeopardy scenario that attaches, and they're not allowed to charge for the same conduct twice. However, they can raise some issues that maybe involve evidence, a pretrial motion, things like that are going to go to the conviction and may have a very significant impact. So I don't know that I would completely say you'll never see an appeal from the state of an acquittal because there are issues that the state can argue about.
But generally, if somebody gets acquitted by a jury and by a jury trial,
that's the end. That's the end. In terms of the state's action thereafter, that's the end.
Right.
So the jury has made that decision and we let that sit.
So then let's talk about the charges that he was found guilty on.
Yes.
Is that it? Is that the end? The jury came back guilty and so it's over?
It is not. So as the defendant, he can appeal if he would like, and he can argue whether the trial court was right or wrong. Now, the importance here is that an appeal is not a do-over. So he's not allowed to say, I don't think the judge or the jury thought this witness was correct. I think she was lying and the jury thought she wasn't. Or I think we could have had another witness that maybe we should have put on and that would have made our case better. He can't say those things.
Or like, I should ask these different questions.
Correct.
My attorney should
Yes.
call the witness back up because we didn't ask these questions.
Yes, there are some protections in criminal law that I think he can argue about whether his attorney did a good job or not. But for the most part, he can't say the facts were wrong. What he can do is look at exactly what happened and talk about whether there was any legal error, where the rules applied correctly. So it's not a retrial, it's not a new trial, it's a review of what happened, which is very important from the appellate perspective. So here, Diddy was he was found guilty of transportation for purposes of prosecution. Now, what he's argued in
Prostitution?
Prostitution.
Mm-hmm.
What he's argued in his appeal is that the conduct that he was somewhat engaged in, which involved a recording scenario, was protected by the First Amendment. And he should have had a First Amendment right to do that, and that the statute that he was found guilty under, the trial court applied the wrong definition of prostitution.
So not that the recording didn't exist
Mm-hmm.
or what was on the recording was wrong,
Correct.
but that he had this constitutional right to it
Yes.
regardless.
So we're taking the facts as they were presented, but we're saying the trial judge should have applied some constitutional protections. The rules were not applied correctly, and that's why we had a conviction that shouldn't have happened.
Interesting. So if what I'm hearing from you, he has appealed his conviction, correct?
Correct. So those are the things that he's arguing now.
So tell me, when we hear the term, I've appealed the conviction, or in this case, P-Diddy has appealed his conviction, what is that process actually like to appeal a conviction?
Yes. So there's a time there. Appellate practice is very time limitation bound. There's a lot of times, there's a lot of rules. So he has to file his notice of appeal within a certain number of days of the final judgment. And that tells the court and it tells the parties that he is asking for further review. It's an appeal. So once he does that, then the case goes from the trial court, the one judge, to the appellate court, which is in federal court, it's called the circuit court. So it's the Second Circuit. It sits in New York. And it's a 3-judge panel that will be assigned to his case.
Okay.
Yes.
What happens at that point?
So from there, unlike a trial as well, where the parties are sitting back and forth and they have a lot of argument, they have access to the jury, they have access to the judge, this is a one-shot scenario, essentially. So the appellant is the person who appeals the judgment, or possibly, sometimes they call it the petitioner.
So P-Diddy.
P-Diddy.
Okay.
He files one brief that outlines all of his arguments all at once.
Okay.
Then the respondent, or the appellee, which in this case is the United States, they have an opportunity to file an answer brief. So they respond to all of his arguments, and they tell the appellate panel why he's wrong. Either the rules were correctly applied, or maybe there's a reason he shouldn't be able to raise this at all, or whatever they want to say to support the trial court's judgment, that's what they're going to say.
And then my listeners are thinking, are we going to trial next?
No, we do not do that. So most cases, unfortunately or fortunately, are decided just on those papers. So
Really?
It never comes to a live discussion. It's just the trial judges and their staff looking at these papers, doing their own analysis, and figuring out what they think is right or wrong.
When you say most, do you know, I know I'm putting you in the spot, but like about how many appeals really get ruled on based upon the briefing, the papers only, and how many of them actually go to oral arguments in front of the judge?
It's a small percentage. I'm not sure of the exact number, but far less than half. It is a small percentage, both in state and federal courts, actually.
Okay.
A lot of cases will just be decided on the papers.
So do we know in P. Diddy's case whether he has finished that stage?
So he has finished. Well, he has not finished his briefing yet. So the third part of that briefing scenario is that the party who appeals gets to have the last word.
Okay.
Just like at a trial as well, where you have your defendant who gets, I think defendant gets to have the last word, I believe, maybe?
Somewhat.
Sometimes. So in an appeal.
The state gets the sandwich
Okay,
in
the
the state
state-
court. In
There
Florida
you
State
go.
Court.
So in an appeal, the party who appeals, the party who's challenging the judgment, they get the last word.
Okay.
So they have that final part. So P. Diddy in this case filed his initial brief in December. The United States has filed their answer brief, I think it was last month. And he gets to file his reply brief in, I think it's March.
Okay.
In April, the court has scheduled an oral argument, so they will discuss what he's argued. And
So what happens at an oral argument?
Oral argument is interesting because, again, it's not like a trial. It's not like you'd think by seeing on TV if you see a lot of these courtroom cases. It is an opportunity for the parties to show up one time and have a discussion with the trial court, or with the appellate panel. So the appellant will start and they will begin to make a presentation based on the arguments made in the briefs, but the judges will interrupt. And they'll ask questions, and they'll say, well, what about this? And do you think you can do this? Or what happens if we decide here? What is my case law telling me? So it, as much as any attorney can prepare for it, it's very much an off-the-cuff discussion. And it's a limited discussion for, in this case, each side gets 10 minutes. And so the appellant, starting, will say, I would like to reserve however many minutes for my rebuttal, usually 2. And then both sides will present, but it's not a very long period of time.
10 minutes.
10 minutes only.
So the entire trial took weeks.
Yes.
And had just so many witnesses, so much evidence, so much talking by the attorneys.
Yes.
Weeks to finish.
Yes.
And yet, for oral arguments, each side only gets 10 minutes.
Yeah.
Is that standard?
It is in the appellate court. So in our intermediate appellate courts, which for the federal circuit is a circuit court, and for the state courts is the district court, most of them will give you between 10 to 20 minutes max. The United States,
not days.
Not days. The United States Supreme Court, I think you get 45 minutes an hour maybe. That's a little bit longer because it's a bigger case. But for these cases, for these intermediate appellate cases, yeah, it's a short period of time.
Wow.
That's it.
So then after oral arguments, what are we going to expect that's going to happen next?
Yes. So after the oral arguments conclude, the judges go back to their briefing room and they talk about the case together, the 3 of them, and they'll make a decision. That doesn't imply that the decision comes out quickly, though, because within the court, they have to talk about it. They'll talk to other judges, maybe. If they want to write an opinion, they'll circulate it within the court. So it takes a long time for a decision to come out in a lot of cases. But ultimately, the end game here is that we're going to get some sort of resolution from this 3-judge panel. And either they will decide for Diddy or against Diddy, and that'll be the end of their decision.
And the decision, is it back in a courtroom like the jury trial was, where the 4-person stands up and announces the decision?
It is not.
In front of court. How does that decision happen?
Yeah, this is for the intermediate appellate court specifically. It's written and it's published, or it's published isn't the right term for it, but it's written and it's put out there in the world. So the parties will receive that. It's just the court's written opinion, and that's it.
Is that opinion something that the general public is allowed to have access to?
Typically, I think that the public can access it or can see it from the website. Usually those things are public these days, I think.
Okay.
Yeah.
And so then what happens after that? So the decision of the appellate court, are there different ways that they could go? Are they limited in how they can rule?
Yes. So in this case, we know that Diddy has appealed and the United States has not. So Diddy, at the end of his trial, he was found guilty of the lesser offenses, not guilty of the larger offenses. So the court isn't going to say, well, he should have been guilty of racketeering. So that's not going to happen. The only thing that we're going to review is what what the jury and the trial court has done. From that point, there's a couple things that could happen based on the arguments that Diddy has raised. And the one thing that they did raise, as I had mentioned, is that they said, with my transportation charge, the court applied the wrong law. If they applied the correct definitions, I wouldn't have been found guilty. So the appellate panel should reverse, and they should tell the trial court I should be acquitted. So if the court agrees with that, that's what's going to happen. So they're not going to say a new trial necessarily.
The appellate court can issue an acquittal.
Yes, because it's an issue of law, and because they're determining how these facts that are already in existence should have been applied, they can find that should be an acquittal. So that's one thing. And if that had happened, then he wouldn't be sentenced, and the sentencing issue would be irrelevant.
So if that happens, he gets released from jail right away?
He could be.
Okay.
I'm not sure if there's a process after that or if there's some sort of technicality administrative process, but for the most part, he's done. That's it. That's the decision of the appellate court. They could also decide that there's no issue with his conviction, but his sentence was improper. And if that happens, then maybe he is also released because he's already served, I think, 18 months.
Right.
He's been sentenced to 50, and they're arguing about whether that 50 was correct or not or should have been applied. So there's a chance that he gets out on that technicality or on that issue because he's already served some time. And then the third idea is that the appellate court could say, no, I see no error. Trial court is right. We're done here. And that would just be status quo.
So if that happened, then his sentence would remain, and he would have to finish out his prison sentence.
Correct. And while the process is ongoing, I believe typically he would be incarcerated unless there's some bail or something like that. But he's serving his sentence. The sentence is valid, and until it's overturned, that's where we are. He could, after this process is complete, either the party that's not happy with the appellate court's decision could appeal to the next highest court, which here is the United States Supreme Court. But in reality, the United States Supreme Court takes few cases. They take cases that either have a conflict or some sort of very important issue that they want to decide. So maybe he gets before the United States Supreme Court, and if that happens, then probably the state would want to maybe keep him in prison. There would be some motions that they might file to sort of address that in the meantime. But their ability to do that is so limited just based on the nature of the United States Supreme Court and what kind of cases it could take that this may be the end of the case for him.
And that's the other thing I was going to ask. So, I mean, we talked a little bit, and we've had a prior episode when we talked about the trial court, the intermediate appellate court, and then the Supreme Court.
Yes.
And so when we're talking about the federal cases, we're in the federal system, so that Supreme Court is the U.S. Supreme Court.
Yes.
But talk to me a little bit, because you hinted on it. They only take limited cases.
Yes.
They only take certain types of issues or certain types of cases. Talk to me a little bit about how a case could actually get to the Supreme Court and why it wouldn't.
Yeah. So, I mean, the United States Supreme Court is interesting because not only is it taking, your appeals from the intermediate appellate court like you would in the state. For instance, the Florida Supreme Court is taking whatever petitions that people file after our intermediate state court or appellate courts. They're also taking state cases on occasion. So there's a lot of volume that goes to the United States Supreme Court. Their procedure is the parties would file their petition. Oh, sorry. Sorry about that.
No worries.
The parties would file their petition for review. The Supreme Court receives that. There's some briefing on that issue as to whether the Supreme Court should take jurisdiction at all. That could be heard by the court, or it could just be decided on the papers. And then once the Supreme Court decides whether or not it even wants to take the case, then it goes to the merits. So there's a roadblock to prove to the United States Supreme Court that you deserve to be there.
And does the United States Supreme Court take most of the cases that are appealed to it?
It does not. No, it takes a very small number of cases, just based on, again, the volume that comes through it. And it's looking at cases that involve some sort of a state conflict. If there's a difference in federal application among a couple of different states that it feels like it needs to address. If there's an issue of federal law that is very important that it feels like it needs to address, then it'll take that and it'll look at that. But for the most part, unless there's some sort of issue, it might not do that. So this is an interesting case because Diddy did raise a First Amendment challenge.
Right.
He's also arguing that the definition within his federal statute was misapplied. So there could be a chance that the United States Supreme Court wants to address that, particularly if there's some sort of a split or some sort of disagreement among other courts. But that would still be a pretty high bar for him to achieve.
And so it sounds like a lot of cases really stay or never leave the appellate court, the intermediary appellate court place.
Yes.
The that court issues their order and their opinion, that's finalized for the case.
That's the end, yeah. And in a lot of our state court cases, for instance, the three-judge panel doesn't have to issue an opinion. They can just say, we think the trial court was right. And if they do that, then there's no basis for further review by the Supreme Court, and that's just the end. That's your right to appeal is to the intermediate appellate court. So
for now, I think our takeaways are, P-Diddy's case is not over yet.
Not over yet.
We will still have to see how it goes.
Yep.
A jury trial doesn't necessarily mean the end.
Correct.
And we shall see how it goes.
Yeah.
Well, Mary, thank you so much for coming on our show, for talking with me about this. This was really fun. And I look forward to continuing to talk with you and see how it goes.
Thanks so much. Look forward to it. Bye, guys.
Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fighting Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fighter Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.